Crimes Against Employees, Module 3 from Readings Part 2. After we've talked about crimes against shareholders, one of the major stakeholders within a firm, the other major set of stakeholders often impacted by crimes, usually by the top executives, are employees within a firm. One of the major areas of that crime is wage theft, and the problems of wage theft enforcement are chronic across the country. Some examples. In New York, Attorney General Eric Schneiderman had extracted settlements from dozens of McDonald's, Domino's locations for not paying employees for off-the-clock work, meaning they weren't officially clocked in, but they were doing work and not getting paid. In other states, California, Michigan, and New York as well, there have been class action lawsuits against McDonald's alleging multiple charges of wage theft, minimum wage, and overtime violations. In California, then Attorney General Kamala Harris had a $1 million settlement with a group of 8 car washes for sub-minimum wage payments and overtime violations. In New York, chronically across even upscale restaurants serving some of the richest residents of the city, busboys were often paid no wages and had to subsist solely on share of pooled tips, often with managers illegally taking a share of it for themselves. Illinois, you had cases of subcontractors who took money from a main contractor meant for wages, but put directly into his own account and not paying the workers fully. So what are the estimates of the scope of wage theft? From the readings, you'll see that for the 30 million workers in what's generally seen as the low-wage workforce, wage theft amounts to $50 billion per year of wages stolen from those workers. Compare this. If you add up all robberies and burglaries and larcenies and motor vehicle thefts across the nation, that was only $14 billion in the year 2012, according to the FBI. So, wage theft is far more than all other forms of sort of small theft across the country. And there's a rising number of wage theft cases, not so much because there's more wage theft, there's always been chronic underpayment, but far more cases getting filed than there were 20 years ago. So what's the impact on low-wage workers? According to the report, Broken Laws, Unprotected Workers, 26% of workers in this low-wage workforce are paid less than the legally required minimum wage. This is surveyed for any particular week. 76% of those who work more than 40 hours per week, and this was about a quarter of this low-wage workforce, were not paid the legally required overtime rate. 2/3, 69%, received no break time at all, even though that's legally required under the law. 30% of tip workers were not paid the minimum wage that they were owed. And even though the tip minimum wage is often lower than the official minimum wage, they still weren't even getting that minimal amount. And when those workers experienced a serious injury on the job, only 8% filed a workers' compensation claim, despite the losses. We'll talk about why in a minute. Retaliation against workers, especially this low-wage workforce, who assert their rights, is chronic. 1 in 5 workers in this study sample reported that they had made a complaint to their employer or sought to form a union. Of those, 43% experienced one or more forms of illegal retaliation from their employer or supervisor, suspensions, firings, and so on. Of those who didn't make a complaint, most reported, as is obviously justified, feared losing their job, and 36% believed it wouldn't help things if they reported it. And if a worker told their employer about a job injury, 50% experienced some form of illegal employer reaction, either firing the worker, calling immigration authorities, or being told not to file for workers' comp. This fear of retaliation explains, despite widespread injuries of various forms, this low-wage workforce doesn't generally file for the workers' compensation that they're owed. In the reports you read, there were a number of suggested solutions to this wage theft problem. One, generally strengthen government enforcement. Hire more government investigators with higher penalties to compensate plaintiffs. Have proactive, investigative-driven enforcement. Identify industries where violations are systematic, whether retail or restaurants, and do investigations to proactively find where the violations we pretty much know are happening are centered. And then update other legal standards. Make sure that people aren't being falsely classified as independent contractors where they don't qualify for minimum wage, and make sure that domestic workers, who are often left out of wage laws, are protected. And you also want to make sure that you protect the legal rights of immigrants in the workplace, since otherwise they become an easily exploited group, which not just harms them, but drives down wages overall, since it's a force that can break unions and otherwise substitute for other workers who might be able to claim rights but won't be hired. You want to strengthen the right of all workers to form unions, since the best way to protect rights on the job is not having outside government, but having workers able to assert their rights, file workers' compensation claims, and otherwise challenge wrongdoing in the firm without fear of losing their job for making that challenge to their employer. But this goes to a broader issue of crimes against employees, which is, how do you form unions and deal with the chronic law breaking that breaks unions throughout the country? Now, in the early part of the nation's history, unions not only weren't protected, they were often criminalized by judges who saw them as an illegal challenge to employer prerogatives. The common law, meaning judge-made law, forbade workers from collectively acting in any effort to gain higher wages. In the early 19th century, at least 23 quote-unquote labor combinations were prosecuted in 6 states, with workers fined or incarcerated for trying to form a union. Even once that formal criminalization ended, judges would regularly issue injunctions against strikes, against picketing, or any other collective action that they saw as financially harming an employer. Any of those economic losses that an employer said that they would suffer due to a strike would go to a court, generate a court injunction, and if the union then defied that court injunction, they would still be thrown in jail. Essentially de facto criminalization. Between 1890 and 1930, there would be 4,300 court injunctions against unions taking action against their employers. The 1917 Federal Espionage Act, officially going after spies and others, was used to destroy many radical unions across the country. Now, the Sherman Antitrust Act had officially been passed to challenge corporate concentration, but most of its early use imposed criminal punishment on unions, while corporate leaders were rarely jailed under the antitrust laws, something we'll return to in a few weeks. In the 1930s, there was a shift to the National Labor Relations Act, what we'd call a regulatory model of labor relations. The first step in this was the 1932 Norris-LaGuardia Act, which was designed to stop court injunctions against labor. It sought to carve out a new legal space for labor law as distinct from criminal law. The 1935 Wagner Act, what's also known as the National Labor Relations Act, legally recognized unions as legitimate actors within corporate structures and markets. It established a separate federal agency to act as a de facto court for labor disputes and charges on either side of the employer-employee divide for what were called unfair labor practices. The 1947 Taft-Hartley Act brought in right-to-work laws, outlawed closed shops, but also expanded sanctions against unions generally, as in a sort of anti-labor backlash against the union wins in the 1930s. The 1959 Labor Management Reporting and Disclosure Act added additional criminal provisions, especially aimed at potential corruption within unions. And the RICO Act, passed in 1970, would also become a tool of regulating unions with criminal sanctions against quote-unquote racketeering, officially aimed at criminal enterprises rather than individuals, but could encompass a range of activities. So what this left the nation with is a split in which courts regulate violations involving corporate management, especially if those actions are aimed at employees, but might also involve employees working with other actors outside of the National Labor Relations Act. Here's the setup of disputes within a firm. Generally, investor management disputes are actually regulated at the state level in chancery courts in Delaware. Only issues of public corporations with securities fraud ends up at the federal government. Actual disputes over the governance of the firm is essentially in Delaware, few scattered other places, but mostly in Delaware within corporate law in those states. Worker management disputes over pay and wages and collective bargaining end up at the National Labor Relations Board. But then you have corporate management that began to use RICO in federal courts against unions when those unions sought alliances with consumer groups or investor allies when they had their own disputes with management. The union use of what was called corporate campaigns was a tactic by unions that would team up with either the union's own pension funds or work with other groups. And by working with other economic actors to pressure management, that would strengthen their hand in labor negotiations. Unions might engage in zoning challenges to employer actions, regulatory actions, make pension fund resolutions, challenge even corporate boards of directors for re-election. This would inevitably mean unions were operating in new areas of law governing alternative tactics. Now, employers would say this was a form of blackmail, extortion, quote unquote, tortious interference in business relations. Now, this was the question. The National Labor Relations Board is supposed to govern employer-employee relationships, but then you have federal courts who oversaw RICO saying, should they get involved in employer-union conflicts? Where do union management conflicts fit into corporate governance, and how do you deal with the reflexive problem of employers often violating the law and the National Labor Relations Act, firing employees, doing otherwise in ways that violate their rights, even as they're claiming the unions are violating other laws by intervening in investor lawsuits and so on. You know, the interesting thing, under the National Labor Relations Act framework, workers are de facto involved in a form of blackmail to extract profits from investors. They're saying, give us a raise or we're going to go on strike. And that was the basis of early criminalization, but federal law says that's the right of people to go on strike. But then you have Delaware corporate law, where executives are literally required under the law to seek the lowest wages that maximize profits for shareholders. They aren't allowed out of the goodness of their heart to give a higher wage to their employees. They may justify paying more as that being better for profits in the long term. But there is within these two legal frameworks an inevitable conflict built into the law in these different corporate judgments. So you have different courts, the NLRB and the Delaware Chancery, each putting pressure on each side to say, go for the maximum profits you have. But then when the dispute spills out into other areas of the law, RICO and various other demands in federal courts may play out. You may have incompatible demands under the law in different courts, and the question is how to resolve that. This really raises an issue of who ultimately is an insider or an outsider within the firms, what are legitimate bargaining tactics, and calls into question simple understandings of what the law of conspiracy is, what even a firm is in all of these different formats. The point to think about on leaving this is as we think about crimes by executives against insiders within the firm, whether shareholders, whether employees, even consumers become a form of insider when they mobilize within pension fund disputes. So the neat categories of the law, often sent to different courts, don't often stay where they should stay as people cross between different court jurisdictions. So what should be neat parts of the law and corporate governance end up not being so neat, especially when you see these labor disputes spilling into these different areas.